Welcome, everybody. Obviously, I've been taking meetings all day in my Oilers jersey, and it's been pretty fun. I have a meeting right after this webinar with a company in Alberta virtually, and they're going to probably wondering why I'm wearing an Oilers jersey, but I'll have to explain it unless they're on here right now. Thanks for coming. We're going to start at 3:01, same format as always. Darcy's going to give a presentation. Only this time it's on HR in Alberta, and you're able to submit any questions. We'll get to them as best we can, and that will be the last half of the webinar. Just want to give a special shout out to my longtime buddy, Eric Hapke. Actually works for the Edmonton Oilers 15 years. This is his jersey. He lent it to me. And as you know, I was born into being a Toronto Maple Leaf fan. My family's been season ticket holders for 67 years. I am rooting for the Oilers this year, and I actually hope they meet the Leafs in the Cup. We know there's not going to be the Calgary Flames in the Stanley Cup unless there's a miracle. Anyways, Calgary, yeah, two great Canadian teams, Battle of Alberta in HR. So this is going to be a lot of fun. We're looking forward to it. Darcy and I were in Alberta this summer, and that's kind of when this idea came up, like, hey, we should do something on HR in Alberta. So quickly, before we jump into it, this is being recorded. It will be sent out on Monday. Before we get into the HR, which is important, Darcy, I have two hockey Alberta trivia questions for you that we're going to start off the top with. Okay?
No hockey.
Right, we know you know HR. Let's see if you know hockey. Who was the Edmonton Oilers' very first NHL draft pick?
Why you got to do that? Why you got to be that way?
You know, Kevin Lowe, 21st overall, 1979. Even most Oiler fans, would probably guess it was Gretzky, who wasn't. I don't think he was drafted. It was from the WHL. Question number 2. 1989 Stanley Cup. The Calgary Flames won. Which other team, they had to be Canadian, did they beat?
Well, it can't be Toronto because they suck. Should make everybody in this webinar happy that I just said that. I can say Edmonton, right?
No, it was the Montreal Canadiens. Montreal Canadiens.
So but I was like, perfect for that to happen, right?
If you've never been on a webinar before, don't worry. Darcy knows a lot more about HR than he does hockey. So Darcy, over to you. Again, if you have any questions, submit them your way, and we'll get to it after. And good luck, Darcy.
Awesome. Thanks, Brett. And thanks, Sony behind the scenes, and welcome everybody to this very special webinar. We're talking about HR in Calgary, Calgary, Edmonton too, and Alberta in general. Sorry, I had to take the shot. But yeah, we're going to talk about HR in Alberta and some specific HR content to the province, which is great. This is the first time we've had the idea to do this. It was Brett's idea on our way back from our Chamber of Commerce Chamber event last time we were in Alberta. So really happy to be here. We have the presentation is going to be a little bit longer than we typically do in our format, just because there's so much to cover. I want to do a little recap of what we did when we were there, when we were in Alberta for the Chamber folks, but also add in some new stuff around policy manuals and requirements there, which I think will be helpful. So I'm just going to get this started up from the beginning. Hopefully everyone can see that. If there's any problem, I'm sure I will get yelled at by Sony and he'll tell me to do something or anything or kick my computer or whatever. But yeah, we're going to jump right in because I think this will probably go about 25 minutes, half hour. Leaves us lots of time for Q&A. We're going to jump right in. Webinar outline, you can see at the back. Brett already mentioned it. If you have questions, we're going to answer them all at the end of the live Q&A best we can. Typically, we end up with hundreds of questions. We can't get them through all. Hopefully, because of the specific content, we might. This is what we're going to be talking about really quickly: the construction of the employment agreement, the termination clause in particular. It's one of the most important because it's the most libelous part of your employment agreement, both good and bad. So we're going to talk about some pitfalls and things you need to be aware of there. Key HR policies and processes, as well as specifically drug and alcohol, social media, and progressive discipline policies, which are 3 policies that are not legally required to have in any jurisdiction in Canada, but these are examples of why policy matters matter, policy manuals matter, why these policies, if you don't have them, anything you do in that realm, whether it be social media, progressive discipline, drugs, and alcohol, you can't touch. You have no power over your employees. So we'll get there. And throughout the webinar, we've taken Alberta-specific case law. So not case law from any other jurisdiction or even the Supreme Court of Canada, Alberta-specific case law to kind of drive home the points, and it makes it more relatable, if you will. So the construction of an employment agreement, let's just go through it really quickly. These are things that you need to have in your employment agreement, and these are for some of the chamber folks. This is a little bit of a recap. That's a good thing. Sometimes it's better the second time around, and you might actually even spur a few more questions, even though we have tons of questions there, which was great. But employee status, method of payment, qualifications, location, worker. Why is this important? Employee status and method of payment specifically. So one of the big misnomers in HR or HR people, even business organizations, what have you, is that if you pay somebody via salary, that salary is encompassing of everything they do, right? So that's actually not the case. In any jurisdiction, there's exempt employees and there's non-exempt employees. An exempt employee means that you are exempt from receiving overtime. Whatever your stated salary is the amount of money you get paid for the work you do. A non-exempt employee, regardless of the method of payment, regardless of whether you get paid hourly, commission, by bonus, by piecework, or by salary, does not matter. If you are a non-exempt employee, after you reach the 844 rule in Alberta, you are entitled to overtime. What is the number one classification by far of an exempt employee? Managerial or supervisory. In every jurisdiction without exception, and it's just a way to the means. It's Ontario. Ontario actually started this. Alberta was the second who kind of caught on. In order for you to be considered a manager or supervisor under the Act or code in this case, begging your pardon, I have to get used to that. Under the code, you have to be doing managerial or supervisory duties 50% of the time or more. Okay, so that's important. You just can't slap the title manager on somebody or supervisor and say, no, we don't have to pay them overtime anymore. The type of agreement, permanent, fixed term, seasonal, again, incredibly important. When a permanent employee is in place, that means their employee has no end date. Okay, so that means they can, and there's other things that they are entitled to under the Employment Standards Code if you are a permanent employee, as opposed to a seasonal employee who there's certain things that they are exempt from. Timelines of amounts of work, we'll get into that later, but there's certain things they are exempt from. So it's important to classify that in the employment agreement for clarity. Preconditions of employment. This is, again, another thing that often gets overlooked. A lot of people say, hey, if, by the way, they do it in their offer letter quite often, which is, if you're a fan of offer letters, and I'm not, but if you do it in an offer letter, it's actually quite an appropriate place to do it, is that you say, we will give you this employment, we will offer you this employment on the condition that you pass a criminal background check, a driver's abstract check, a credit check, all of which you can do if it's part of the bona fide occupational requirement of the job. If it's not a bona fide occupational requirement of the job, for example, you can't ask for a credit check, or you can't ask for a credit check if someone's not dealing with cash or finance or money. Has no bearing on the job whatsoever, right? So you can't ask for that. But if it is, you can make it a precondition of employment. You want to submit your policies as contractual. This is, I had this debate with an employment lawyer 2 days ago who was trying to argue about something, saying these employment policies that your client is holding my client to were never given to him at the point of signing the employment agreement. And the lawyer's actually right. We were lucky enough that we had a clause built in their employment agreement that said you will receive your policy manual at hire and you have 14 days to ask any questions, which is an implied understanding. If you don't have something like that in your employment agreement that ties your policy manual and your company policies to your employment agreement, the conditions of signing, then it's possible, especially for short-term employees, that your policy manual and the policies therein are not enforceable as conditions of employment. It's super important to know. You don't go get a lease and then sign the paperwork and then the bank gives you all the terms after the fact. If you want the policies to be part of the employment relationship, they need to get it before they sign, or there has to be something in their employment agreement that denotes that they will get it after and they'll have an opportunity to respond. Important terms, and we're not going to go into these today, just because we're doing a high-end overview. Layoff clauses, severability, confidentiality, a non-disclosure agreement, injunctive release, renew and refresh. All these things, I know they're legal jumbo, and we have so many employers and clients that say, I don't want an employment agreement that's 7 to 8 pages long. Folks, the employment agreement is the only time when you have 100% control over the process. After that, anything you do in the changing of employment, anything you terminate, you discipline, what have you, if you didn't submit what your protections were in your employment from the jump, then you either have to get permission, you have to give working notice, you have to give consideration to the employee. This is the only time where you have 100% leverage. So yeah, if your employment agreement is 6, 7, 8 pages long, so what? It's for your protection. It doesn't protect the employee at all. Make no mistake, if anybody is out there believes an employment agreement is good for employee and employer, they're wrong. The employment agreement specifically and only to protect the employer. And then restricted covenants like termination clause, non-compete, these are incredibly important. So there's very few, like the provinces now, like with around a non-compete, for example, provinces now are starting to eliminate non-competes. They're starting to make them illegal to insert in employment agreements, namely Ontario, who's the first, but there's provinces that will be following. One of them at this point is not Alberta. So you have an opportunity to put a non-compete in your employment agreement for Alberta employees. You want to think about it, but there's caveats to that, which we can discuss, because I know I saw a question come in before the webinar in the Q&A, so we'll get there for sure. Termination clause pitfalls, and again, being mindful of time, I'm going to go through this relatively quickly. You must be limiting, you must be clear language regarding entitlement and compensation. Okay. Benefit, like with the termination clause, you have to be very distinct about what they're entitled to at termination, what they're giving up. You just can't say this is all you're going to receive. You have to say, for example, if you're going to limit common law, if you're going to limit whatever payment they get, the Employment Standards Code, the termination clause has to name what they're giving up. In other words, you are giving up your entitlement to common law entitlement or any other entitlement that you may find through an alternative dispute mechanism. It has to say something similar to that in the employment agreement. You can't make the assumption that the employee is signing away on something they don't know they get. Okay, so that has to be named. It has to be clear and non-ambiguous. And perhaps outside of Ontario, perhaps in no other jurisdiction has the courts swung in the favor of the employee than in Alberta. On this note, and Alberta traditionally, as people at the Chamber of Commerce know, because I said this a few times, Alberta traditionally, and still is, the most right-wing employer favorite state as far as legislation and application thereof. It's very employer-friendly relative to other jurisdictions in Canada. The courts are coming around, though, to the other side, specifically on this issue. So here's an example. A termination without cause, this is the clause they had. The company may terminate employment without cause upon providing the employee with notice as mandated by the employment standards legislation, or such additional notice as the company, in its sole discretion, and here's the word, may provide at our option, pay in lieu of such notice. Basically, the Alberta Court Justice struck that down, stating because they use the word may, there's a possibility, or at least an interpretation, which is likely, if not desirable, by the employee to say they're entitled to more than the Employment Standards Code notice. Okay, that's important. The court does not accept ambiguous language. If you're only going to pay out Employment Standards Code and that's it, you don't in the lines such as additional in the sole discretion may provide. You can't, right? If you want to do that after the fact, unbeknown to the employee, and you want to make it surprise, knock yourself out. That's what the termination negotiation process is for. But you don't put it in an employment agreement. Termination clauses have to be like ironclad. And here's another example of the same thing, Brant versus Parkland, Alberta Court of Appeals, and this is back in 2022. So we're not talking like landmark cases from 10, 20 years ago. We're talking about within 2023, 2022. We're talking about the last couple of years, where this contract may be terminated by the employee by giving the board 30 days or more prior written notice, by the board giving the employee 60 days or more. The or more clause said by the Alberta Court of Appeals said this clause is no longer valid or enforceable. So it's super important. It sounds like you're being strict. It sounds like you're being, the bad guy, but that's what employment agreements are for. In both cases, the employers had to pay tens of thousands of dollars more in termination costs than what they believed they had to at the time of termination. So that's what you're looking at. And then it has to be clear in its application. Okay, so there's certain things that you have to understand. So for all of you people, if you have not had your employment agreement reviewed in the past year, because again, 2022, 2023. So if you had not had these reviewed in the last couple of years, and there's a big case in Ontario that is transcended across every jurisdiction, and that happened last year. So if you had not had your employment agreement reviewed in the last year, it's 90% chance that your termination clause is not enforceable. You can give them a new employment contract to your employees, but in order to do so, for it to be a legally binding contract, because you're going to be getting something out of this. You're going to get an updated employment agreement that suits you. You have to provide consideration, which is something of value. You just can't give them a new employment agreement and say, sign here, we're going to take your job away. You have to sign here and give them something in return for that to be enforceable. That's the nature of a contract. Both parties win. If both parties don't win, it doesn't have to be equally, but if both parties don't get some type of benefit, it's not a contract by law or an enforceable contract by law. Okay, how are we doing? 3:15, right on time, kind of. So let's talk about key HR policies and processes. And this is cool. This will be new for all the chamber folks that are coming back to hear this again. This is great. This is something we didn't discuss in our last seminar when we were there. The legal benefits of a solid PM. Okay, so there's a whole bunch of other things that come with a policy manual, you know, culture and all that kind of stuff. That's not my type of HR. I'm about liability. I'm about protecting my client, working from worst case scenario first. So this is what I'm talking about today. So sets expectations for the employee around conduct and performance. Again, critical. Compliance with laws, clear process of employee issues, helps defend against employees' claims. This is big, right? This goes back to where someone says, I did not know I cannot do that. I did not reasonably know that this was a meaningful expectation of employment when I first started here, that I couldn't go on social media and say something nasty about another coworker or the company. I did not know that. And you know what? If you don't have a social media policy, you can't fire somebody without cause for exactly that reason. Okay, so that's why a policy manual is important. Legislative required policy. And I made some notes here that I want to refer to as well as we go through, which I very rarely need to do, but in this case, I want to be on the button for all of my Alberta peeps. Legislative required policies. So you're talking about things that are legislative required from an HR perspective, and some of this crosses over into health and safety, by the way. Actually, they do. Most of it's health and safety. I'll be brazen. There's very few policies that you are legally required to have in any jurisdiction, including Alberta, legally required to have. You're talking about a handful, but those aren't the policies that are most effective for you. Those are just the policies that the government wants you to have, mostly to protect the employee, not necessarily the employer. So you're talking about health and safety policy, a workplace harassment policy, a violence policy, WMIS. These are the things that are required to have in Alberta, right? Why is this important? Why are these policies important? Because they can protect the employer too. Let me put it this way: if you don't have them, they're definitely not going to help you, right? They're only going to help the employee. But in a case like this, you'll see the corporation and the city of Calgary versus Amalgamated Trust. This is a case where an employer terminated a manager because they had, how would you say, off-duty sexual assault. So it had nothing to do with work at all. It was off-duty, but it happened between a manager and their subordinate, and it happened outside of work. They had a functional, working, well-written workplace harassment and violence policy, which clearly stated that your conduct extends beyond the workplace. If they didn't have that, I can tell you right now, or they didn't have the policy period, I'm going to tell you right now that that person that employee terminated with cause is going to sue them for a lot of money, because you can't pull something outside of the workplace into the workplace unless you have a policy. That's what policies do for you. They set the parameters, they set the framework, right? So it's super important. That's a great example of why legislative policies are required and important. Human rights and accommodation. This is another policy that is either required or encouraged in almost all jurisdictions. Same thing in Alberta. I will tell you this though, of all the provinces, for the reason that I mentioned earlier, that Alberta is more right-wing leaning for employers than any other jurisdiction, a human rights policy is super important. Because oftentimes, and it's been this way throughout like recent history in Alberta, the Human Rights Code and the Employment Standards Code clash. For the longest time, and this is the only jurisdiction in Canada where they had it, the Employment Standards Code had a caveat in their workplace employment legislation that says, if this clashes with the Human Rights Code, the Human Rights Code may take preference. You know what I mean? That's, to me, I'm like, well, fix the code then. You know, if you know that the Human Rights Code is going to overrule you on these different things, what are you telling your employers? Are you setting them up for failure? So they have gone a long way. The code is farther along than it was a decade ago or 2 decades ago, but still, it's important to understand that human rights is a policy you should have. Accommodation is a policy you should have. And here you'll see a case where an employee was pregnant. There's 2 lessons here. An employee was pregnant and had some medical issues that came along with that. They're not required to disclose their pregnancy, but they did disclose their medical issues and asked for accommodation. The response, for reasons that the employer denied, was simply that we're not going to provide the accommodation, and if you can't do the work, then we're going to terminate you, which they did. She took it to the Human Rights Code on the basis of pregnancy. The employer argued that the employee never told them they were pregnant. So how can it be a protected status? How could it be in the Human Rights Code? And this is the second important part. This is why you need the policy first off, but this is the second important part for anybody who was part of our last webinar when we talked about managing disability claims and managing, claims management in general. When someone goes off sick leave, the employer has a duty yet obligation to inquire. You just don't simply accept a doctor's note and say, oh, thank you. off work for 3 weeks or need accommodation for no particular reason, you have a duty to inquire. They did not inquire. So they gave up their right, they gave up their rights and privileges and protections around not doing their job. And basically the Human Rights Code awarded her 7 weeks pay, $35,000 in damages and costs, right? So that's a $50,000 mistake, which if they had a policy would have fixed all that, okay? Operational policies, hours of work, overtime, vacation, PT. This is where we start to get out of the requirements, but these are the policies that matter most for functional day-to-day companies, okay? Hours of work, overtime, vacation, PTO, all these things are super important, especially in a province like Alberta, where they have the 844 rule, which is far more complicated than any other jurisdiction as far as overtime goes. So you want to be clear about what your policies are around that. Make sure you're paying out overtime. Make sure you're paying, all those things that your obligations and employees are clear on it. The chef, this should be scary. This should be scary because this is one of the first cases in all of Canada and any jurisdiction where a court actually, looked at this and said, okay, we're going to do it this way. In this Shuffler case, an employer or an employee sued for overtime that wasn't paid. Under the code, there's a 6 months kind of statute of limitation in which you can go back to get unfair paid practices by the employer, and you can get reimbursed if the ministry finds that you were wronged. So this actually went back. They figured that they were not getting paid overtime for well over a year. The court actually allowed it to go to a civil case, to an Alberta King's Bench case, for the period of time that exceeded the 6 months that was the ESC. All this means for employers is the statute of limitations for you when you're not doing the right things is null and void if an employee has the money and the will to take it to court. That's a dangerous precedent for employers in Alberta. It's like I said, the courts in Alberta have moved so far to the left, probably in part because the employment legislation is farther to the right and traditionally has always been that way. So it's something for all of you on this webinar to be, cognizant of. Jurisdiction and industry specific. So whether it be if you're in a factory, you might have to have iron stations or forklifts or chemical showers. If you're in a hospital setting, it's going to be sharps or disinfecting personal protective equipment. Farming has their own set of regs. So for all those people in Alberta that have questions about farming regs, I'm not so sure I can help you. I can get you any answer you want, but it's a very detailed set of regs all by itself, and it's separate and distinct from what is your most common ESC, kind of regulations, working heights, etc. All of these things that, depending on your jurisdiction or your industry, in this case, industry, because we're speaking to a specific jurisdiction, you need to have. And then these are the 3 policies we're going to discuss in a little bit more detail. And again, it's 3:23, so we're going to spend about 3 minutes on each slide, and I think we're good. So drug and alcohol policy. This is an important policy, and I'm going to tell you why. I'm going to tell you why. Actually, the next 2 policies, why they're important. I'm just going to speak to it broadly. Alcohol and drugs are legal. Most types, all alcohol for the most part, and most types of drugs, I shouldn't say most types of drugs, many types of drugs, depending on which jurisdiction you're in. In some jurisdictions, almost all of it's legal. In most jurisdictions, marijuana and things of that nature, and even prescription medication, right? So it's important to know that when an employer comes into your workplace and they're hammered, or they smell like weed or whatever it is, and you say, you know what, get out of here. You're a health and safety risk, completely within your right, because they're a health and safety risk. So you can send them home. Then you bring them in the next day and say, we're terminating you with cause. Right? You can't do that. You would think you could do it. A reasonable person would think that if someone came in hammered, even after being told don't do that again, and they did it again, that you could terminate them with cause. But what they're doing is not illegal, right? So they have to do something that, if it's legal, they have to be held to a standard for which they can be told you're going to be terminated with cause if you do this. That's the policy. Whenever you have something that's legal in society, but you don't want it in your workplace, the only way to get the power to terminate somebody with cause is to bring it into your workspace, and that's what policies do. Okay? For cause terminations, I just talked about this, so I'm going to skip right over it, basically saying if you don't have the policy, you can't get it. You can terminate them without cause. If you're happy about paying somebody months and months and months for coming to work, knock yourself out. But me personally, if I tell somebody when they come and they smell like weed, and I say, listen, do you have a problem? No? Okay, then it's recreational use. You can't do that here. And that's what the policy says, so if you do it again, we're firing you. I'd rather not have to pay them. That's just me. All at once. Reasonable suspicion. This is everywhere. This is one of those places where Alberta is actually winning, right? I'm going to use a case that actually, because Suncor has so much, like I mentioned it when I was at the Chambers event, I was going to talk about one particular company without naming them. Well, here you are. Suncor has enough like money and and they also have, care for their employees, care for the community and all those different things, but they have enough funds and resources to be able to put something together that no other company in any other jurisdiction similar has the willingness or desire to do. So basically in a case like this, the court ruled that they could not do a pre-incident testing based on the fact that it was a near miss or an accident or something like that. They had to do more. If you have reasonable cause, right? If you have reasonable cause and someone gets to an accident, you smell alcohol on them and all that kind of stuff, you could test. You could test in almost every jurisdiction as long as you need to have a policy, of course. If you don't have a policy, it's a human rights violation, period. It's a violation of their privacy as well, right? But if you're going to do pre-incident testing or pre-employment testing, the court basically said you have to go beyond the actual incident. You have to prove that the environment itself is dangerous and the factors that are in that company or the factors that are in that area or city or program or what have you have dangerous undertones. Like there's inherent danger without even considering the job. But then when you consider the job being safety sensitive and the inherent danger that already exists, then in that case you can do pre-incident testing. At that point, Suncor didn't have it. This case was so important for Alberta and Suncor because the court simply recommended, the arbitrator in this case simply recommended a few changes to say, this is what you need. Suncor was able to implement those changes, and now it's become what became a big loss for Suncor and Alberta employers. It's actually become a learning lesson and a big win. Right. So Alberta is so far ahead of the game in this area, in large part because of the oil industry and things of that nature, where, being on a rig or something like that and being high could cost people their lives. So it makes sense to that regard. Human rights. So this is the other big thing. And again, Suncor has been good at this. Most employers across the country are good at this if they have it. But you have to understand, whether you like it or not, that drugs and alcohol are in fact an addiction. Right. And as they're an addiction, or can be an addiction, as they can be an addiction, and disability is covered under the Human Rights Code as a protected status. If someone has an addiction in the workplace and you try to fire them for that addiction, you can be violating the human rights, just as this person did, a person who was clearly an alcoholic. They admitted this person asked for help to the employer, asked for help. And the employer ended up terminating them. And they gave all these different other reasons about why they terminated them and said, hey, this person, is there a bad employee? Well, that's because they're addicted to alcohol. You can't take the cause and the nexus. You can't separate one from the other. Either way, it costs them over $70,000 in damages. So it's important to note that the proper procedure when you encounter somebody with a scent, clearly inebriated, clearly under the influence, what have you, is, get another manager to come in, do a reasonable suspicion checklist. So there's two different people. It's not subjective. It's not one person's opinion. Two different people kind of checking this person out. If you both make the assertion that this person is under the influence, send them home because they're not safe to be there. When they come back the next day, the first question you should be is, you're going to confront them with the incident. The first question you should be asking is, do you have an addiction or a dependency on drugs and alcohol? If they answer yes, there's a process to go down that we're not going to go down today. If they answer no, then you could start to implement your policy, right? So that's all very important. But the key is that human rights must come first in the implementation of any drug and alcohol policy in the workplace. That took 4 minutes. So social media policies, this is a little bit quicker. I'm just going to throw it all up in there just for the sake of time. So what you're really considering is that it's, again, just like drugs and alcohol, it's not illegal to speak crap about another person or your employer on social media. Can you get sued civilly? Absolutely. But is it illegal to use freedom of speech as long as you're not doing hate speech or things of that nature? There's nothing illegal about venting your opinion. And we see this in the United States right now, and to a certain extent in Canada with, what's going on with Trudeau and Poilievre and what have you. Well deserved, by the way. But sorry, political opinion. But you see this a lot in the States between, the Republicans and the Democrats, and people like even the president and the running president, like you see this between them, the clear almost defamation of character that's allowed in politics that wouldn't be allowed in the normal day-to-day. But in Canada, freedom of speech exists. So an employee going on and doing something that you would take exception to, ripping a client, ripping you, ripping a coworker, what have you, you can't fire them for a cause, again, unless you bring that power into the workplace. They're doing something which is a constitutional right. They're doing something which is completely legal. The only way you are able to bring that into the workplace is to have a well-written social media policy that clearly states, this is what we condone, this is what we won't condone, specifically what you won't condone. And it typically is, defamation of the company, defamation of our clients, defamation of other workers, anything that has to do, like speaking poorly about, right now, with IBGQ, whatever that is. Sorry, I always get the what do you call the initials mixed up. But right now with the EDPD. Right now with the world we live in, it's super important that we are respectful of everybody's values, and it's important that if someone speaks online about something that is not reflective of the company's values or culture or missions or goals, that you have the power to discipline them and or terminate them. One important tip that I would provide to all of your employees: make sure that the account of that employee is not at all associated to the company. So Facebook's an easy example because it actually asks on there, who's your employer? Who are you employed by? As soon as you put who your employer is, anything you say on your social media page, anything you say on your Facebook page, you could be held liable for by your employer if you have the policy in place. So it's super important to keep an eye on that. And then we're going to do our last slide. We're actually almost right on track, so it's great. Progressive discipline policy. It's important, especially if you're in a unionized environment, to make sure that progressive discipline is followed in a consistent manner. If you're in a unionized environment, you leave yourself open to grievance when you discipline somebody for one thing at one level and then discipline somebody for the same thing at a higher level or not discipline them at all. It leaves you wide open for a grievance because it's an inconsistency and equity of the application of the process. So it's really important that in your progressive discipline policy, you have certain standards for what will reach your level of discipline, what will be considered a heightened discipline, because you can skip steps. And this goes to that point. Not all conduct or behavior is equal. So if you have a person that you're investigating, for example, for sexual assault in the workplace or sexual harassment in the workplace, you go through the investigation, which you're legally obligated to do, by the way, and then you get to the point where you've made the assertion that this person has committed sexual harassment in the workplace, and then you turn around and you give them a verbal or a written warning. If someone called the ministry, they are going to fine you. They're going to, because that is equivalent to condoning a behavior which is clearly accessible. Giving a warning for something that could be worthy of termination, or at the very least a last warning before they are turfed out the door, is what needs to be done. And if you don't do that, you, the employer, even though you did the investigation, even though you did the discipline, but if you don't discipline appropriately, not only does it send an awful message to your team, to your company, to the city in which you work, you know what I mean? It can find you liable with the Ministry of the Labor Board. Documentation, I'm telling you right now, folks, 90% of the progressive discipline policies that I read are fine. 95% of the templates that those same companies use in the progressive discipline process are awful. There's 4 things that you have to have in every discipline. When you have one of those things that, I see these checklists all the time where it has discipline and it says level 1, check, level 2, check, level 3, take that to court and see where that lands you. Every discipline has to have specific letter issued to denotes the type of discipline, what they did, what they need to do better, and what the consequences are going forward. The last thing being the most important thing. In order to get cause in any jurisdiction, and that includes Alberta, you have to be able to show that at every level of the progressive discipline that they were aware of the consequence of continued disobedience or continuing to not follow the rules. If it doesn't show a heightened level of consequence at every level of discipline, your written templates, it's not going to last in a court. So that's super important. The policy is important. Your templates are just important. And just remember, when you're doing a progressive discipline process, and this is frustrating for a lot of employers, there's really unless it's deemed harassment, which is really difficult to pull off in progressive discipline because the employers have the right to manage constructively and discipline accordingly, you'll never get challenged in a court. The only time you're going to get challenged, the only time any of these documents that we're talking about on the left-hand side there, where it talks about, these are the things you need of every little step of the discipline, the only time that's ever going to get challenged is when you actually go to terminate with cause. And then all of a sudden, the court's going to look, or the labor board or the arbitrator, they're all going to look at every single discipline you provided. And if there's something wrong with any single one of them, your case for cause is gone. So it's really important that you do this process right, that you have the policy that clearly outlines the process correctly, because if you don't have the policy and you don't have the proper templates, getting it for cause termination, for progressive discipline is not on your radar. Breath. Waiting for my thing. Hey, Alberta. So thank you everybody for chiming in for that. We're going to do our Q&A. I really appreciate, having the opportunity to speak to the folks from Alberta. It was a hoot, for lack of better words, visiting all you folks when we were out there. I had a great time. Your hospitality is off the chart. So, and looking forward to, I think we're going back next month. So I'm looking forward to it. So I'll turn it over to Brett, the Edmonton dude, and we'll go from there.
Awesome, Darce. Thanks a lot. That was great. It's a lot of fun to kind of dive into a province like this. This is our first time we've done this before. Let's get into the questions. We have 25 minutes. We have lots of questions here. So let's go. The hours of work and overtime. The hours of work and overtime requirements for our employees in Alberta are a little bit complicated and expensive for our company. Is there a way we can manage our costs for overtime?
There is actually, and it sounds like this might be an employer that has employees in other provinces, because there's a sound of relativity there, and it's more complicated than Alberta than any other jurisdiction. But you can do something called an averaging agreement in Alberta. So you can do it in most provinces. It's just a little bit more favorable. I think in part because there's a lot of complication around what substitutes, like the overtime rules. The actual, the averaging agreement rules are actually very favorable in Alberta. So you could have an averaging agreement that goes from 1 all the way to 52 weeks. And most jurisdictions will not allow that, right? And you only have to provide a couple weeks notice to your employees that you're going to be putting it in place. But essentially what this does, it allows you to average, like if you're averaging it out within a week, when you have the 8 hours in a day or 44 in a week, if someone worked more than 8 hours in a day, but you averaged it out, so they were working less than 44 in the week, then you don't have to pay them overtime. If you average it out over a 2-week pay period, which is really common, most common to be honest, to average it out over 2 weeks or a month. Basically, if someone worked 50 hours 1 week and then the next week they work 30, that's a total of 80, where you would have had to pay them 6 weeks under the 6 hours of overtime the first week. But when you average them all out together and make it flat, you owe them no overtime. So an averaging agreement is definitely the way to go in Alberta, particularly because it can be very costly to have to pay employees overtime with your 844 rule.
Do we have to pay casual workers statutory holiday pay in Alberta?
Yes and no. Going off memory here, but if my memory serves me, if a worker has not worked more than 30 days in the last 12 months, the 12 months prior to the statutory holiday, then they do not qualify for statutory holiday pay. So that's super important in seasonal industries, and one of those, when you're dealing with young workers or students, because again, young workers and students might not get it anyways, but when you're dealing with, just somebody that might come in a few hours here, a few hours there to help out, if they haven't worked more than 30 days in the last 12 months prior to the statutory holiday, then they're exempt. So it's a kind of a yes and no, but it's better. Most provinces say no matter how long you work, or no matter what kind of worker you are, you're entitled to statutory holiday pay. So Alberta, again, pro-employer on that one.
We have an employee who has been with us for a month. They told us that they need to take a leave to look after a family member who's very ill. Can we simply deny the leave or even terminate the employee since they haven't been there for 90 days?
Okay, so this is a great question, because this is exactly the conflict I'm talking about between the Employment Standards Code and the Human Rights Code. So first off, there's two things there. There's denying the leave and then there's termination. We'll do the denying the leave thing first, because in order to be eligible for a protected leave, you have to be with your employer for 90 days. So in spite of what your employment contract says around probation or anything of that nature, in order to be eligible for that leave, you have to be there for 90 days. That does not mean they're not entitled to it under the Human Rights Code. So when you tell somebody that, hey, you're not entitled to that Employment Standards Act leave or the Employment Standard Code leave, that's fine. That's within your right. All that means is they're not entitled to the protected part of the leave and everything that comes with it. But if you still deny them that leave, they could argue for family status reasons, which is a protected status under the Human Rights Code, that you're discriminating against their family status. So under the Employment Standards Act, completely legal to deny them the leave. Under the Human Rights Code, not so much. Same thing with termination. If you were to terminate that employee because they're in their probation, if you will, then that would make sense. But the actual reason you're terminating that employee, and you would be hard pressed to prove otherwise, is because they've asked for a leave of absence, which you don't want to provide. Again, human rights issue, you're discriminating against that person on a basis of family status. So that's the danger. Like when you read employment legislation that gives employers more rights than not, as relative to other jurisdictions, but then you bring in the Human Rights Code, which is, you know, overreaching all jurisdictions, regardless. You have to be always considerate of what the Human Rights Code versus the Employment Standards Code says and who has jurisdiction. And in 99% of the time, it's going to be the Human Rights Code.
So in that circumstance, you would say give them their leave.
I would say, I would make it clear that it's a good question because the qualification is awesome. I would say we will allow the leave, but because you're not eligible for a protected leave, it's a leave of it's an approved leave of absence. Basically, what that means is if operational needs should dictate and you have to let go of that employee, and you could show that operational needs were the reason why you need to let go of that employee, and it was not because of the fact that they asked for the leave, then you would be able to do so, and their only recourse would be to go through the human rights process or a court. They would not have access to, you know, the employment legislation people in Alberta that might mitigate that process for them quickly and less expensively.
Excellent. Nothing simple, eh, Darcy?
Never. Not even icing the puck. It's like an equation. Sorry.
That's good.
Love the movie Goon.
Well, so, you're a baseball guy, right? Like you played up, you know, baseball is your sport. So, and baseball is big in Alberta. They got a like out west. There's a pretty good. I know my buddies in Edmonton. There's a pretty good. I don't know what level it is. If it's like the equivalent of AAA in hockey or whatever, or like the minor system. But there is really good ball in Alberta.
Yeah, they play.
I obviously have no idea what I'm talking about because everyone in Alberta is like, this guy has no idea what he's talking about baseball. Okay. If we permanently lay off an employee for legitimate business and financial reasons, do we have to pay them anything, or do we have to pay them the minimum termination pay as per the code?
Okay, sorry, I was just, kids are walking in, so I was just a little bit distracted, but I think I got the question. First off, because I heard the term permanent layoff, there's no such thing as a permanent layoff. So we did a webinar on that about common misnomers in HR. Permanent layoffs is termination. You can call it a permanent layoff if you want, but at the end of the day, it's a termination. There's the only thing that exists in any Employment Standard Act or code, including Alberta's, is a temporary layoff, right? So when you do a temporary layoff, that lasts, I believe it's 90 days in Alberta. So it lasts 90 days. On the 91st day, that person is considered terminated. So if you're doing a layoff, then you don't have to pay them when the layoff commences. You just have to let them know that a layoff is coming. But on the 91st day, it's a termination. Or if you're doing a termination or equate to a permanent layoff, as much as I dislike the term, it's the same. The same thing on the 91st day as the first day would happen, depending on what. Long story short, you pay them at the minimum what the code states, but depending on other factors, you might have to provide common law as well. And the factors that you're considering for those people not familiar with common law is the Bardell factors, which is the older they are, the more money they make, the higher their title, the more difficult it would be for them to find comparable employment. If the courts rule that, you know, a person that is 60 years old making $150,000 a year and a director's title is going to take 6 months to find another job, that's how much you're going to have to pay them. And, you know, that the fact that you're doing this for operational reasons that are justified, the courts do not care. And I have to be really clear about it, because a lot of employers, we get client questions at least a few times a week, but we have to do this. We have to lay this person off. We have to terminate this person. We have no money. We have no jobs. I go, I'm empathetic, and I'm an employer rep. I'm on your side. But at the end of the day, the courts don't care. You're in a legally binding contract, which is what an employment agreement is. You offered employment in exchange for pay. You are canceling the contract. You have to pay what's owed. The reasons why you need to cancel the contract, the courts give no concern to. That it's, for lack of better HR terms, it sucks for employers.
The Employment Standard Rules website says that we do not have to give vacation in the first year of employment. Is this true, and do you recommend it?
Yeah, we get this question every once in a while too. You don't have to give vacation time. So this isn't an norm. There's a difference between vacation time and vacation pay. So it's super important for employers. So when you look at it from this way, let's say 2 weeks. So 2 weeks equates to 4%. So vacation time is 2 weeks, vacation pay is 4%. Vacation time is 2 weeks. In the first year of employment, it's kind of like a roll it forward system. The government actually sets employers up for success, but 90% of employers, or even 95% of employers, don't use it. As soon as an employee starts work, the minute they start work, they start accruing vacation pay. But the vacation time, and they're accruing it just like the 2 weeks over the course of the year. You do not have to allow them to use the 2 weeks of vacation time they earned in the first year until the second year. And while they're using their vacation time from the first year, they're accruing vacation time in that second year to be used in the third year. It's like a pay forward system. That way, the reason being is you're never paying somebody unearned or unaccrued vacation. So most employers won't do that. They won't employ that system, albeit they're right, because of recruitment and retention. Because most people want to take vacation. And if you said, hey, we don't give vacation in the first year, they're just not going to take the job. But in reality, you do not have to allow them to take vacation. The other thing about vacation pay, which a lot of employers seem to get stuck on, is even though it's 4%, it's 4% of all of their wages. So if you have an employee who has a $50,000 salary, makes 10,000, so you're going to base the 4% on the $50,000 salary, right? If they made $10,000 in bonuses and commission as well, you have to pay the 4% on the bonuses and commission as well. So most employers are kind of getting there on that because this is so well known now. It's just more information out there, but there are still a lot of employers that are not aware that the 4% or 6% after 5 years that you use to calculate vacation pay is based on all wages, not just your set hourly rate or your salary.
Interesting. Didn't know that. Can we include non-competitive clauses in the agreements of our Alberta employees? And what is the difference between a non-competition and non-solicitation clause?
Yeah, both good questions. The one I actually mentioned, and that was happenstance. That was just like literally happenstance that I mentioned it in the thing. But yeah, you could still, as it stands right now, Ontario's firmly on the other side of it, and other jurisdictions are talking about or have something on the table to actually remove non-competition. The idea behind a non-competition meaning is that you can't work in a similar industry, in a similar geography for this many years of time, typically 1 to 2 years. And it just basically says you can't go work and be one of my competitors or work for one of my competitors. The problem with it from a common law point of view, which is theory of fairness, is you're telling somebody in their field, like this is what they do for a living, that you can't earn a living. So a lot of jurisdictions are looking at it and saying, yeah, we're not going to do that. Which brings you to the non-solicit, which again, you can use a non-compete. The courts rip non-competes if you don't word it in such a way that it's reasonable. Even if you're allowed to do it, the chance of you actually having an enforceable non-compete, even drafted by an employment lawyer or by us for that matter, is probably about 10%. And it's because it's just against the concept of common law. So the courts are going to look at every plausible way to shut it down as they can. And the Supreme Court of Canada has made no qualms about it. Anything that contradicts common law, even though it's the employer's right, we're going to do everything in our power to hold your feet to the fire. They're unapologetic. So, but a non-solicitation, on the other hand, that's legal in every province still. And it's more effective of a tool because what that basically says, you could still work in the industry. You can work anywhere you want tomorrow. That's fine. But you cannot solicit our clients. You cannot solicit our employees. You cannot solicit our contractors. You are not allowed to use any of our confidential, proprietary pricing, client information. You can't use any of that. And if they do, it has the same outcome of as a non-compete. You could actually sue them for either financial and or reputational loss. And then one of those clauses that I mentioned in I mentioned a clause in the PowerPoint gives you the right to actually, put them on hold, put them on ice until it actually goes and gets to a court. So, a non-solicitation, again, it's very specific about what it can't do. It's not an overall encompassing thing where you deny somebody the opportunity to work on their field. It's way more effective. The courts they look upon non-solicits written properly and reasonably as very favorably because they see it as the strike and balance between the company's competitive advantage and their right to privacy and proprietary rights and all that kind of stuff, but also telling the employer you could still go make a living, or the employee can still go make a living. So yeah, non-solicits are, even though you could use a non-compete, I don't necessarily recommend it. A well-written non-solicitation is probably the way to go.
What are your thoughts on NDAs being signed at the time of termination with or without cause?
they don't have to sign it. So like this is the thing. If you're getting someone to sign an NDA, you have to be giving them more. First, you have to be, if you're terminating them and you're giving them the employment standards code minimum, it's not enforceable. You can't enforce the NDA because you're giving them what they're entitled to. So ask them to sign off on something additional is not going to happen. If you give them something, like if just say they're entitled to 4 weeks and you end up giving them a second 4 weeks in exchange for you signing this full and final release in the NDA, sure, absolutely, no problem. But you put yourself in a libelous position in so much as, or not a libelous position, you put yourself in a position of less leverage that you actually have to give them something and hope that they agree to it and sign this NDA, as opposed to at the time of employment, when you say, here's an NDA, sign it, and if you don't, we're not going to give you your job, which is ultimate leverage, right? Hey, these are the terms of wanting to work here. You want to work here? Sign this, right? Why would you not do it then? Because if they're not going to sign it then, if they're not going to sign it as a conditional employment, trust me, you're not going to get a determination. You definitely don't want them as an employee, right? If I ever had an employee, and I've been my 30 years doing HR, I've never had this happen where I've had an employee I've had to ask them to amend an NDA, but I've never had a potential employee refuse to sign an NDA. And I'll tell you right now, if I ever had an employee refuse to sign an NDA, there would be a fireball out his butt out the door. So it was like, I don't want somebody like that as my employee.
We are headquartered in Alberta, but we have employees working in other provinces permanently. Do I need an employment agreement for each province?
Great question. With the exception of BC, yes, you do. So the jurisdiction in which the employee resides, and this is important for all you people that have remote workers that extend beyond the border of Canada, right? So if you have workers working in the Philippines or United States or Austria or wherever it is, so they could name a million countries, wherever the jurisdiction is that they reside, for the most part, not all continents or countries are this way, but certainly the US and Canada is, wherever it is the employee resides is the jurisdiction which must be followed. Now, there is something that came kind of to light in COVID. It's trying to remember the name, rule of choice of rule or whatever it is, one or the other, where basically you could put in the contract that upon agreeing to this contract, you agree to accept this province's rules, legislation, and as long as it's not a worse benefit, courts have generally accepted it, but they turn it down as much as they accept it, because it's never been tried at a high court that you're actually signing away your jurisdictional right to be governed by your own employment legislation and laws. You're signing that away. Inherently, that's not allowed. But courts in COVID they looked upon it somewhat favorably. It'll be interesting to see. So to a certain point, cases like things like that are kind of important. It's going to reach a higher court. It's going to reach an appeals court. It might reach the Supreme Court, at which point we can speak to that. But we do provide it. We will offer to our clients as long as they understand the liability that it may not be enforceable. But yeah, if you have a problem, if you have an employee in every jurisdiction, you need employment agreements for every jurisdiction and employment legislation or employment manuals for every jurisdiction and trainings geared to that requirements in that jurisdiction. It's expensive.
No kidding. For online training, if the employee chooses to complete it at home instead of on site at work, do we still need to pay them for their hours to complete the training since we can't verify how long it took them to complete it?
If you're requiring them to complete the training, then you have to pay them. So you could say that this training takes, like most training sessions, like even us, when we give you our synopsis of our training sessions, we'll tell you it will take 45 minutes. Technically, if it takes them 2 hours, you're technically legally required to pay. So if you are worried about that, make them take the training at work. Most employees
can't do that.
What's that?
You can say as the employer, no, you got to take the training on the computer at work when you're in the office.
Absolutely. Yeah, absolutely. If they're worried about privacy or anything, but I don't know why they would be, but if they're worried about privacy, just give them a space to work with a closed door. Yeah. But it would be no different than any other type of work they were doing. If they could do this type of work, like any type of administrative work for the company, they could certainly take the legislative required testing in an open area. But yeah, if you're worried about your employee kind of defrunking you or defrauding you on how much time they're taking to do this training, then make them do it at work.
Yeah, we got about 5 minutes here. I don't think we're gonna get through all the questions, but we're gonna try. Do probation periods go both ways? Can the employer say that you're on probation for 6 months and in the offer letter also say that the employee must give 2 months notice to leave?
Yeah, it's interesting because if you tell the employee, I'll answer the latter one first. if you tell the employer that they must give 2 months notice, now in Alberta, it's not a problem. In other jurisdictions, it is. You can't do that. Because again, that's restricting their right of movement, which might come to Alberta one day as well. So it's helpful to know. But if they turn around and give you 2 months notice, and that's exactly the way you worded your employment agreement, you must give us 2 weeks notice. If they give you 2 months notice and you don't want it, they're a bad employer, you just don't want them there for 2 months, you have to pay them for the 2 months. That's on you. So you want to write something in there that you must provide us with 2 months is, they could challenge you on reasonableness as well. Again, restriction of right to move, right? But if you said a month, which is more reasonable, if you said you must give us 4 weeks notice, the employer reserves the right to pay you the minimum entitlement based on your years of service as per the Employment Standards Code and refuse excess notice. You could do that. In a case like that, if they've been there for 2 years, they're owed a couple of weeks pay, they give you a month's notice, you could say, we're going to let you go. And here's 2 weeks pay. But yeah, as far as on the other end, providing, probation, you just have to keep in mind, a probation period is not something you're going to find in the act or the code. The terminology does not exist. The terminology is made by employers. We, as employers, develop the term probation period to tie it to what the Employment Standards Act or code provides for that period of time in which you do not have to pay. That period of time which you do not have to pay an employee, typically 30 days, 90 days, depending on the jurisdiction, is set in stone. You can give somebody a 6-month probation period. It's actually become relatively common. Year probationary periods have become very common for executives and senior leaders. But after the 3 months, you must pay them their termination notice or termination pay at a minimum, regardless of what your own probation period is.
If you discipline an employee because of a conflict, or if you discipline an employee, how much can you tell the other employees about the discipline, about what happened? Like, can you say what happened? Can you not say? Like, what are the rules there as the employer?
You shouldn't be telling them. Like, there's very few times when an employee is privy, because everything that happens in an employment relationship, there's union environments that actually go against this, and that's their right. They don't have to follow the ESC. They don't have to follow certain privacy legislation if it was collectively bargained. But in a non-union environment, outside of it being a workplace harassment or workplace violence circumstance, or outside of someone being unsafe, you are not entitled to share what would be considered confidential information in an employee's work file, their workplace, the things that happen to them. That's between you and the employee, not anybody else's business. So you could tell you can tell another employee that, yes, we've looked into it and we've taken appropriate action. When you watch CNN or Fox and they always say, yes, we've looked into it, we've taken appropriate action, you always get frustrated because you feel like they're covering something up. Most of the time, that's because that's all they can say, right? So in this case, this is all you can say. We've taken appropriate action, we've dealt with it accordingly. And that should be good enough. And if the employee wants more, you simply say, unfortunately, it's confidential. It's an employment thing. They're entitled to their privacy and confidentiality in that regard.
Last question. What are your options to discipline an employee if you do not have any policies in place?
You can discipline them as much as you want. You knock yourself out. It's just you'll never get a termination for cause. So, like, for me, because in most cases you have the right, like, I'll be even more brazen on this. I am not the biggest fan of progressive discipline, and I'll tell you exactly why. Because it's very difficult to get a termination with cause in any jurisdiction. Any jurisdiction, it's difficult to get a termination with cause, and if you don't have a policy, it's impossible. So this is on both cases. For me, when you get to the second discipline and you notice that this employee is not a good fit for your company, and you're going to likely have to pay them out anyways, why are you spinning your wheels? Get rid of them. Pay them out the road. Get them out the door. So you're going to spend all this time going through a progressive discipline process, and then 2 months down the road, even if you've done everything right, you fire them with cause because they're not getting EI, because they have a black blemish on their record, just because they're ticked off and they have all the time on their hands, they might even sue you. So now all of a sudden you've done everything right. You spent 3 months babysitting an employee, and now you have to go to court or go to a third-party tribunal just to defend yourself, where you might actually even win. I'm like, I'll pay the guy the 2 weeks or the girl the 2 weeks prior and just be done with it. There's a certain point. You always want to be supportive of employees, and you always want to give them that opportunity. But at a certain point, just make sure the effort and time that's put into the process, it equals the benefit at the end. So, but in this case, be specific to the question. If you don't have a policy, you can discipline all you want. It's a corrective tool. But if you ever tried to terminate with cause, it won't happen.
Okay, excellent. We're out of time. Darcy, that was awesome. Hope everyone enjoyed it. There was 5 questions we didn't get to. That's my alarm to take a call in 1 minute wearing this jersey. But again, it's being recorded. It will be sent out on Monday. Thanks again for tuning in. Yeah, let's do this again next year at some point. That was a lot of fun. Thanks, everyone. Darcy, anything else?
No, man. Thanks. It was great. A lot of fun.
Go Oilers. Destiny. All right. Even though, and for the record, I'm a Leaf fan, but I mean, you know, we know what that means. All right, guys. Thanks a lot. Have a good day. Bye.